इस में ऐसे अपन देखेंगे फायदा नहीं बना okay well इस तीसरे साइड इसके साइड इसके जो स्कोर के रेकॉर्डिंग तो ये रखा है
Yes.
Malaks, in the morning I mentioned about item number 150, Malaks. Your Lordship directed me to inform the police council, Mr. Amit Puri, have informed me.
For what?
For taking the matters personal matter, my Lordship directed me to.
Will not be able to.
Malaks, may keep it for day after tomorrow, Malaks. Or is it the personal matter of Mr. Puri?
Might be. 150.
150, Malaks.
24 color. रख दो उसको। 12th February.
At 2 Malaks,
12th February, not at 2 a.m. 12th February. You make a mention on that.
Supplementary, item number 151 to 164.
Final. Item number 151, CBI is also part of the having history. Fine.
151 भाई मेन फाइल ही करी है वाली स्टेट की You are in which case?
151.
Yes. Number 10. So the pro forma party. Why was it a pro forma party? Is there any
in the original petition notice, they have been made the pro forma party.
they have been shown as a pro forma party?
Even the original petition.
Then what? Then all right. So they were not served. You were not before the single judge. Then how do you say that there were pro forma parties before the single judge? Was there a prayer?
Was there, yes, sir. There was a prayer that the matter should be investigated by the CBI. In that way.
ठीक है, let it give pro forma. You watch the proceedings. If required, we will call you. Yes.
State appeal.
You take up which appeal? This appeal number 1346. 1346?
Yes.
All right.
So to appreciate the judgment and the controversy, timelines and the exact time to steps, very big or very relevant. On third of
ये copy और ये written notes. Yes, yes. Let's start from this. So advertisement was issued on 3rd of February 21.
for 1,859 posts. After the month and
All right.
total 797,030, 7 lakh, more than 7 lakh applications were received, and in the written examination, 3,83,728 persons appeared. The written examination was initially scheduled on 4th of September 2021, but on 28th July, this was spread on 3 days, 13th September 2021 and 15th September 2021, 2 papers into 6.
No. Written examination was conducted on 13th September 21
Yes,
to 15th September 21.
21 into 6, because there were 2 papers.
Okay.
Then original result was declared on 24th.
This examination was conducted where? At one place?
Several centers.
Several centers in one district? In Jaipur?
7 headquarters.
Various districts at different centers.
Where have you mentioned it?
That period I have shared with you.
How many places? How many places it was held and conducted, and how many centers in all?
I will give the exact.
All right. Yes.
And then but it was throughout the state, centers were there.
All
in
right.
various districts.
So in one district also there were several centers.
Yes. One district also there, according to need, according to the examining over to because
Tentatively, how many persons appearing in one place?
they details, specific details I can provide, after asking. But they said there was 7,97,000 applications.
There were 3,83,728.
Both appeared, but so far when I have, the RPSC has to decide as to where the examination has to be conducted.
So you issued admission. You issued admission cards for 7,97,000.
They are the applications.
So you issued admission cards.
RPSC also have issued the admission cards.
Okay.
But when deciding as to how many centers where they should be there, the number of applicants plays a pivotal role.
Yes, that's what we are asking you.
Applicants and therefore throughout the state centers were designated.
Good.
And since this large number of persons were there, earlier it was decided to hold on 4th September by a notification of 22nd June 2000.
That-
But
yes.
looking to the large number of candidates who applied, it was spread in 3 days in 2 shifts.
Spread in 3 days in 2 shifts. All right.
And then the result was declared on 24th of December 2021. Now at this stage, I will show from the judgment the details. In September itself, on 13th September itself, there were complaints registered in the form of FIR that at some places dummy ad appeared, one has been found to be dummy. That the paper has been leaked.
In some place.
Center, specific center-wise FIRs, about 8 to 10 FIRs were already registered.
On 13th.
13 to 15th, for a few days later, but before this result was declared on 24th of December, FIRs were there. It will be important for the reader below that in 2022 itself we have also been turned to the next phase. The physical efficiency test was conducted on 2012 because it is 3-stage examination, written examination, physical efficiency test, and then interview within 3 progress. So up to 18th February, the physical efficiency test was conducted and the result was declared on 11th of April 2022, in which the persons were to be called for interview. On 1st of June 2023, the interview result was declared, and then appointments were to be issued thereafter. But before that, your lordship will see part 2 of it. Need persons who are petitioners in this subject and lead petitioner being Kailash Sharma. If he along with others, about several 34 petitioners, they filed a petition before this honorable court alleging the same very thing which has been alleged in the instant case. They gave the details of FIR registered and alleging that the sanctity of the examination has been completely compromised because of paper leakage or the dummy candidates appeared, and therefore the examination should be cancelled. Because the clear prayer made there.
In repetition?
It petition number 7264 of 2022, filed on 4th of May 2020. This fact has come in judgment, not even the prayers of the notice. On 18th May, the notices were issued to the respondents, and the state government filed its reply on 5th of July 2025, indicating the outcome of the FIRs and investigations. It is filed 7 2022. By mistake, it has been filed as 25. In that, it was indicated that the investigation in 2 matters, FR was submitted, in others, some investigation proceeded found something wrong.
This reply is there on record somewhere?
There in that petition, a set of which was provided to the honorable. The petition was not pulled from the record. However, this was brought to the notice of the court, and the petition and the reply, etc., submitted before the notice.
Yeah.
Then, 21st July, these petitioners, 3 of which are the petitioners in the present petition in a joint petition, they withdrew the petition without seeking any liberty to file a letter, and the petition was therefore dismissed and quit. Now, thereafter, they go on awaiting. So, Lordship will find the appointment orders were issued on 21st of September 2023. 780 candidates out of 869 were appointed on 21st of September 2023. 4th October, 19 candidates, then 9 to 2024, 86 candidates, and 6 to 2024. 2 candidates were. So all they were awaiting the note, but what happens in between is the notes. When the new government came, SIT was appointed for investigating not particularly this case, but paper leakage complaints which were being received, and it was an issue during the period, and there was a declaration that nobody will be left. Everybody who is indulging in this will be punished. So SIT was constituted in December 2023. The SOG then registered 2 FIRs. One is 2 of 2024.
Where is that mentioned?
All these facts,
They are not mentioned in this.
I will show the judgment, but broadly I am telling that.
So in December,
December 2023, the
SIT was formed.
SIT was formed. One FIR was registered number 2 of 224, which related to some APA. It is in the judgment which was possibly see. Depends on the FIR.
These are correct.
These are facts,
These are the facts which are correct. You admitted.
I agree, they are mentioned in the present that page.
Advocate General Sir, you please understand one thing. Our first order is that the learned single judge has relied upon documents which were without any affidavit. And therefore, we would like to know from you that these facts which are mentioned in the judgment, are they correct? And you admit them. We go with this understanding that whatever facts are mentioned in the by the single judge are correct, and they are and the state agrees to it.
So far, this registration up to this, whatever I have stated, I agree to. Where
FIR 2/24 was registered by the SIT. SOG, all right.
And the other was 10 of 2022.
10 of 24.
It was registered on 3rd of March 2024. The first FIR was registered on 1st of January 2024.
All right. Why two FIRs?
First was with regard to a specific incident without one single individual who didn't appear against whom one dummy candidate.
So when that FIR, as you told, there was already an FIR registered on 13.
There were several FIRs, if you also will turn to take.
We want to know from you, as you are saying, before we go to the next fact. So far as FIRs which were registered between 13th and 15th,
Yes.
when the examination was going on, what happened to, what was the fate of those FIRs? There also this was somebody has impersonated, that was an FIR.
Yes, but at a particular with regard to a specific individual.
Yes. Now this FIR is with regard to another individual.
It's another individual for which they have registered in February 2026.
All right.
The earlier FIRs, some task sheets were filed in two matters, FR was given. There was a separate investigation going on at various police stations.
All right.
Based on that, a petition was filed before the Supreme
That you have said.
No, then the second FIR is a bit strange FIR in the sense that there was a FIR already registered in which investigation was going. There was revelation of certain gangs involved in the paper leakage, etc. Based on that, SOG registered a FIR number 10 of 2024 for a wider investigation.
Or investigation relating to the gangs which are involved in impersonation and
individual, the broader things which were being revealed during the course of investigation is separate FIR number 10 of 2024 was registered.
all right.
I am telling all these facts to tell your lordship,
Yeah.
that it is not that the state government or its agency or not acting at all, hiding anything, actually they were otherwise in paper leak, they were arrested. They were brought before the court, their bail application on a technical ground was allowed, against which a 482 petition was filed, and the order of the magistrate was brought placed. People were put behind it, and it was continuing. At that stage, it was to this explosion of arrests, etc., after registration of this FIR. The government asked the SOG as to what is happening. What do you think about this investigation which is going on and its impact on the
selections which are
selection process? SOG, while investigation, getting an investigation in various spheres was still ongoing, gave a detailed report, where they drew conclusion based on the arrests, etc., made that it seems that it is so widespread that it will be very difficult to segregate the tainted from the untainted, and made its recommendation. There were preliminary recommendations based on 3-4 months investigation which was made, and then this report was agreed to by the Director General of Police. It was sent to the government. Governments obtained an opinion from the SE based on whatever material in the report was given by SOG.
All right.
Based on whatever was stated in the conclusion drawn at that point of time, Advocate General also opined that this it will be difficult to segregate and therefore it will be appropriate that the examination is cancelled and those who appeared in the examination, they are given a chance. In a fresh examination, those applicants only who appeared and who may have suffered because of this, they are given a chance to appear afresh in the examination and based on that result, action is taken. Those who may have resigned from services in the state, they may be given a chance to rejoin at their place if they are not selected. And request can be made to the other states or agencies from where they have resigned and came. In this sort of opinion was given. It was then placed before a ministerial committee. Ministerial committee, based on whatever was the status of the reports, etc., also opined in the same manner.
All right.
And then the matter was sent to the highest level for considering it. In the meanwhile, investigation.
Yes.
And what was what was at the initial stage, what was happening in the investigation, it was found that the assumption to the effect that it is large scale or it will be very almost impossible to segregate the tainted from the untainted, etc., doesn't seem to be going in the same manner, irrespective of all efforts, additional arrests were being made. So nobody against whom evidence was found was being spared. They were being arrested, booked and put before the honorable court for further action, and even almost 39 or so their services were terminated based on whatever material were found against them that they committed a fraud, they were involved in this wrong and therefore their services were terminated. So the government was not lacking in any.
How many? 39?
At that point, 39 were terminated, and then later on, this investigation is still going on. This investigation was being carried out, and whoever is, wherever there is evidence that it is involved, it is not being excused. That is a very important aspect which is required.
Till now, how many?
Today I can't say, but when this.
So 39 were removed that time. 39 were removed that time and terminated.
Even after the judgment, several were arrested, but in that case, their number is not proportionally so large. That can be the argument will be.
So that means what you are saying is that now, on further investigation, it could be found that tainted can be separated from those who are untainted.
But I am coming to that. Then what happens when a petition is filed alleging that SOG is not doing anything, it is under administrative pressure and therefore it is not taking appropriate action. On 13th August 2024, a petition is filed here. On 13th August 2024 itself, the SOG sends its recommendation for cancellation of the examination. It is said, my lord, nothing is produced by the petition and a false argument is made to the effect that went to the higher authority and they didn't give any hint and the SOG people told that they are being pressurized not to recommend for cancellation. The question is, my lord, there are therefore several questions of maintainability were raised, which have been answered, my lord, and I will say that the manner in which the submissions were made and the judgments which were cited and recorded in the order sheets on the date of hearing, they have not even been referred to when the final judgment is rendered and discussion is made. That will be one aspect. Therefore, I am telling all these facts, my lord, and then we on 21st of August this 2024, this petition is registered. 31st August, my lord, one of the members.
You say it was filed on 13th August.
Yes. And on their date, the SOG already recommended. On the same very day, recommends for cancellation, and they plead that SOG is under pressure, administrative pressure, not to take any such action. That is why this petition that monitor the investigation and all those where I will come to that. They filed this fresh petition, 3 of them already withdrew the petition.
They jointly filed with others.
Yes, and others who find out many of them were those who didn't even receive the qualifying marks in the written examination. So even otherwise they would not have been affected. Let us say to a person who has benefited from paper leakage. Reverse can be to a person who appeared and scored very high, more than at least qualifying marks. But one who outstayed at the initial stage, they also joined these 3 persons. And nothing of their status what was disclosed in the petition as to how much they scored, up to what level they were selected, and why they are accredited. General allegations to the effect that there was a mass paper leakage, the dummies have appeared, FIRs have been registered, those very FIRs which were mentioned in the earlier. Most of them were these, except these 2 petitions which were registered by SOD. So the activeness of the government in unearthing the wrong has been made as a basis for issuance of a recommendation. And conceive the previous CTS. When I filed a reply on behalf of the state government, they filed a rejoinder below. In rejoinder they say, when I say that they have come in 2024, after awaiting all the appointments and we were sending the people in training, they have come and therefore in service to jurisprudence relating to recruitment. They must have come in time. They came to, then they replied, that 2-3 petitions were filed earlier, but do not disclose that very petition in which they were petitions. In the rejoinder. I am telling all these facts to say, that the honorable thing is that reports are finding that it is a bona fide omission. Not a concealment which could have attracted the rejection of the petition. So then, they don't place it immediately if it was so urgent. They gave the petition registered on 21st. 31st, arrest of one daughter of a RPSC member, Ramuram Raika was made. Then on 1st September 2024, arrest of RPSC member was made. 2nd September 2024, another RPSC member was arrested. And then on 25th September, based on newspaper report, they file an affidavit. And all these they don't immediately place it, get it adjourned, and then suddenly, after these arrests, they place the petition and the current order is passed. So this is how it has proceeded and then what happens is, what is important is without these proceedings before the honorable single judge. I made a specific submission before starting my submission.
Now this was an RPSC member, Ramuram
Raika and Babulal Kaha.
One thing we want to know from you, 13th, 14th and 15th September you have conducted examination.
Yes.
The paper must be different. Paper has to be different.
And if you are
And then it must have been, you must have carried out an exercise of scaling or normalization.
Scaling was done.
That was not done.
No, that was done.
normalization was done. RPSC.
It must have been done.
It was done, sir.
So the paper which was leaked by these RPSC members was which one? Was it the paper which was published on 13th, 14th or 15th?
For all 3 days, Lord.
No, can't be like this.
There are not specific.
It must have come in the investigation.
State living, these queries which are now coming for the first
But-
time, but we will, I will assure your worship that we will.
Mr. Rajan Prasad, why we are saying so is, if we are to say that certain part was tainted and certain part was not tainted, or that if all the 3 papers have been alleged to have been leaked, then the aspect will arise.
Understand your worship's query, but since these specific questions were not there, so on
All
record,
right.
because these are not there, we will give a specific answer to this.
You said that the
And
member.
what I will be saying, my lord, my lordship will be as to whether it is a case required to examine the merit of the matter. That was the main argument before the honorable Supreme Court. At outset, I said that it is not a PI. It is a service writ petition, and therefore, when examining a petition under Article 226 with reference to a matter relating to employment, the petitioners have to prove their case and their right. If they are disentitled to come for securing the end of justice and sanctity of the process of this concept.
But can we save such an examination which is tainted? Once it has been brought to the knowledge of the court, that's certain. And if the persons are participants in that examination and have been deprived to be selected by one government. See, when you said that these people could not come in the cutoff, naturally somebody else has come in the cutoff on account of being tainted. So the people who are below, they are completely ousted. So they will come to the court. Where is the occasion of their not being?
I perfectly bow down to your lordship's observation. 3,83,728 candidates participated in the examination. Then we made a submission that this X who has come to the court for these reasons which are well established principles of law declared by the Honorable Supreme Court is not entitled to invoke the jurisdiction. It is not saying, my lord, that the others who are entitled to that come to the court.
Were they not participants in the written examination?
Not participants, they came to the court, they refused the petition.
That is one part. That is.
That is where the
Can the others? Can this be a reason for the others who, on the basis of the subsequent information,
Yes.
out of the say 70 persons file petition, 3 are those who have come again?
Yes.
Can they take away the right of the others?
The others, if they join together with those 3 and the affidavit is filed by the person who was a party to the petition
Earlier. Yes.
and then the concealment is made. These persons who join in a joint petition cannot claim any right to it.
Yes.
Saying, you know, that out of these 3,83,728 candidates, thousands may be such who could have come to the court and said that the material which has come before the now after investigation is sufficient to get the examination cancelled. And then your lordship could have not examined the merits as to whether the decision of government to not cancel the decision to cancel will be premature, will be a different. But those who play with the court, and those who become fancy,
That is one part.
it was the main issue before the court, my lord, and we insisted that these matters be decided on the basis of law letter. Our submission was, my lord, that matter may be of public importance. If somebody file a PIS saying that the persons who are found to be guilty of these misconducts, if they are appointed in police stations, the public will suffer and therefore examine the matter. It could have been different. It would not have been a service PIS. It would have been a grudge or demands of the citizens who will suffer at the hands of
All right.
those who are to be appointed.
We have got that aspect which you have said.
Every
But we will not now, once the other parties have also been given an opportunity of hearing, and the learned single judge has gone into the merits of the case.
yes,
Whether he could have gone on the merits, that is one aspect.
yes,
But once he has gone into the merits, and the merits are before us,
yes.
on that merits, please address.
I will show to your lordship, my lord, that the learned single judge exceeded its jurisdiction.
That
In examining the merit of the case, that will be the first aspect.
that is first aspect. We know, we
So
have.
once, if I am unable to satisfy the honorable court, my lord, that the manner in which the proceedings have taken place and the excess of jurisdiction, then of course, my lord, I will be making submissions on the merit. But here is a question, my lord, that out of 3,83,728 persons, 34 comes withdraw the petition. And then some of them, only 2 of them,
Three.
And the lead person being the same, who filed the earlier petition comes to the honorable court. Other same no grievance, no allegation that this was a mass leakage. We have suffered. FIRs were registered in the month of September 2021, and the honorable signature said that there is no delay at all.
Where was the occasion of the government to again then issue the SOG?
Hello?
At that time, when the earlier petition was withdrawn,
Yes.
then the matter should have attained a quietus.
Yes.
But the government has issued an SOG.
Government is
Has again, so the cause of action can be said to have arisen again.
I may be clear with you. I am
We are understanding what you are saying,
Ah.
but so far as grievance before the court is concerned, has to be examined on merits now. Especially in appeal when we are here before us.
in what situation mandamus is issued.
You have arrested, you have removed RPSC members subsequent to the withdrawal of the writ petition.
Hello?
After the withdrawal of the writ petition, the court, the concerned officer, concerned petitioner, being satisfied that you are taking action, may have withdrawn the petition.
That's the
There is nothing mentioned in withdrawal order.
no. That is below the date makes it clear.
Wait.
Withdrawal takes place in July 2022.
And in 24, you have arrested
Yes,
people.
so 24 when I arrest people, below those who have not been before the honorable court, they could have come to the honorable court with a grudge.
We-
But then what happens is below? What was their grievance? That I
We-
didn't take a decision.
Mr. Rajendra Prasad, we can't put the things under the carpet and say on this primary objection, and we say that no, we will not going to.
Observation because I will demonstrate later on. That as a matter of fact, what happens below? There was no decision taking. We were below making arrest. Recommendations were being made before that he comes to the.
Yeah.
He did not come with the report. He comes to the court and says that you cancel it. Our objection was that when I am active, I am performing my statutory or constitutional obligation. There is no question of the writ of mandamus being issued. The matter was being heard, and we were able to convince the honorable secretary that after this investigation has gone so far, let the government take a decision as to whether the cancellation should be made or not. Then the committee was again made below. All concerned departments reports were submitted. Comparative charts were prepared as to the district highly affected and whether it was as a matter of fact large scale in the sense that every center or the entire state or substantially the entire. All these things have been and then the SOG later on responded that still the investigation is going on. We are likely to make further arrests and then it will be clear as we will be able to segregate the tented from the untented. That is the report.
Right.
The SOG gave. Then we got the committee took a decision that it will be premature to take a decision to cancel at this stage. However, action against those who are guilty should be continued. Their decision as per the direction from honorable court was placed before the honorable court along with the material on the basis of which the decision was taken. Now the petitioners do not question it. After placing it, we said no. Government has taken a conscious decision not to cancel at this stage. If its validity is to be examined, it has to be, its decision has to be challenged for reasons 1, 2, 3, 4, 5 to which we may answer. The petitioners choose not to challenge that decision. They say no, whatever prayers we have made, they are sufficient for this. So, one affidavit after affidavit, material was being placed, some material even without affidavit. And that was being taken on report because the RPSC secretary was called in camera and then he has been at how to proceed, everything has been done. The head of SIT, he was called upon and then he divulged the information before the honorable court in open court. It will prejudice the entire investigation. Then it was kept in camera. So, as a matter, very important aspect of
And that has come in the order?
Yes, there are the honorable single judge had directed every day.
No.
Yes, when he was called and when it was kept.
That's all right, it was called.
Yes.
But with regard to the discussion which has been done, has it been?
Not been reproduced, but
All right.
it has not been reproduced, but there is order sheets. Some reflections on what has been said has been made. Look, the question is what if the honorable signature would have been trying a public interest litigation for the benefit. Of institutions which were in the request. The manner in which RPSC, because it is all with regard to the conduct of examination was all with regard to the domain of RPSC. So if the manner in which RPSC conducts is to be examined by the honorable court, then firstly the honorable court shall have to see as to whether the institutional sanctity of this very court is being preserved, whether the persons before your lordship, whether they are abusing the process or they are entitled to be heard. That was the first question.
It's not that part. What we understand is that the honorable single judge
Yeah.
has examined whether actually there is this entire examination is tainted or not.
So what is the basis? The
Now,
basis-
once it has been brought to his knowledge by the placing on record facts relating to the paper news, arrest made, SOG report, if
I will come on those principles.
whether the court can examine it or not
Court-
on its own.
Court should not have examined on its own for the purpose of public benefit, simply for the reason that after 2010,
There is a precedent for it. There is like this kind of a judgment. There is already a precedent judgment which was rendered in Punjab and Haryana High Court by relating to Haryana PSC. If you remember, the entire PSC officer, including the chief minister, were arrested. And that judgment relating to an examination, public examination conducted by the PSC, was examined thoroughly by the court.
there are
And the High Court has the power that was held by the Supreme Court.
I am
And the High Court has a power to go into each and every aspect, can even call the secretary, can even call the SI.
I am not on that question. What I am saying is, in an appropriate petition filed by a person entitled to invoke the jurisdiction under law, the court may examine all the issues and the honorable courts have been examining, questioning the examination, maintaining the examination. That is not it.
So come on that aspect. Come on that aspect, sir. This is, so far as the power which has been exercised by the single judge comes within the four corners of 226.
No, that is where I go down your lordship's observation and I wish to make submission.
Though we lay down our own fetters with regard to the petitioner having been coming second time or third time.
Those are not mere things. Your lordship may appreciate, there is law which is statutorily enacted. There are provisions of the constitution and then there is law declared by the Honorable Supreme Court made binding under Article 141 of the Constitution.
That is what we say. But those are fetters.
Said that such like petition deserves to be dismissed at the threshold, the honorable court could not have gone on merits of the matter. That is the submission and the judgments which were cited before.
Relating to allegations of such kind of examination.
Below,
Relating to if there is an allegation
yes,
which subsequently again is found that it was a tainted examination.
yes.
Can another petition be not filed?
Another petition can be filed by a person who is appropriately authorized. But that's what I am saying, that on the date when this petition was filed, there was nothing more than what was already within their knowledge and they consciously chosen to withdraw the petition and then to conceal it. The concealment has been dealt very seriously by the Honorable Supreme Court below. Howsoever good ultimately may result. The question is at whose hands and on whose request this Honorable Court in its jurisdiction. The Honorable Single Judge could have, what I am saying is, I argued and I from the High Court rules that if at any stage in a petition which deserves to be dismissed at the outset, if the Honorable Court finds that it is a matter of larger public importance, this should not go unattended. The procedure is provided below under the High Court rules that the Honorable Single Judge could have taken a suo motu cognizance which have come before it, would have placed before the Honorable Chief Justice, a petition would have been registered, and then the entire thing would have been opened. Because when we say
But
that
you are talking about the matter and the procedure which has been.
Yes.
Procedure left.
the manner in which it has been done, if the, and those rules were framed because of the fact, that Honorable Supreme Court while deciding the Uttaranchal matter said that not everybody should start acting upon suo motu and there should be a procedure. Directions were issued to frame the rules and the rules have been framed. So I am not saying, that the court is powerless to undo a wrong. Here the question is in what manner it has been done and whether the court which has done, after considering our objections, whether those because our objections were rejected, and then the procedure for the and concealment itself amounts to abuse of the process of court, and then therefore it is a material fact which has been concealed and it should be thrown out. And this happened when over anxiousness, something which was not said in the court, literally going to the root of the matter was recorded as my concession. I had to file an application for recall, and on that this is recorded.
On 8 July.
8 July this order is recorded after I filed an application that I didn't say that it is sufficient, my lord. The affirmation which has been recorded is not correct.
So affirmation was recorded when? To this order.
Yeah.
On?
Already first.
7 July.
Yes, 7 July. The last portion is Case 3. Initially, my objection that it is not mass, etc. has been recorded, and then last 3 lines of there 2. More so, it is affirmed that due to the said malpractices, the authenticity, fairness, transparency, and legality of the examination in question is affected. If the Advocate General affirms this, what remains for argument for this thing? So, this is how things have proceeded, and that is why it is very important.
Either step
And because the Honorable Supreme Court has said procedures are not merely technicalities. Generally, it is said that the court generally should not be swayed by technical considerations. But all procedures are not mere technicalities.
Yes.
They are meant.
Then on 7th July, this 10 July, what have you said?
8 July, I am telling that these submissions.
7.1.
It was with concealment. Taken preliminary pertaining to present days of petition with the ground, have approached this court with unclean hands and have concealed and suppressed the material facts. In support of the fact contention, reliance is placed on these judgments. No, the judgments which were relied upon by the other side have been dealt with. But in the judgment, none of these judgments at the time of argument without the relevant portions were referred to stress that these persons didn't deserve any indulgence. Then second, without these judgments were with regard to estoppel and constructive res judicata on the basis of principle of order 23 rule 1. The Honorable Supreme Court has said, and the judgment were cited to the effect that it is a matter of public policy that if a person withdraws a petition without liberty of the court, and it equally applies to its jurisdiction, and the person's the fresh petition his BS cannot be entertained. These judgments were cited. And then we got lectures, etc. in the matter of recruitment and all that we got awaiting. And on the issue of members, these were the judgments cited before the compilation of which with an index is a different thing, after referring to them, their relevant portion that is not agreed upon or distinguished is a different. But when it should go on the principles of natural justice, what is the use of submissions made? If they are not there, we need the judgment.
All right. Further.
So now there are. So and I will demonstrate from the judgment, the other side's judgment which was right.
Has he anywhere dealt with your preliminary objections?
Yes. Lordship may come to the judgment. Page 15A, there are 38. 27 moments. Discussion. It starts from the 36.
Yes.
No, this is previous conduct and constructive right to the data. No, this was not. It was not a mixture of argument. It is not previous conduct. It is a conduct during this petition itself when they conceal facts, and therefore this entitles themselves from. And that is a principle. Concealment is a different principle, and the other principle of estoppel under Order 23 of not being entitled to maintain a second petition is a different. No, here you also will find, that the distinction which has been drawn are very interesting, and none of the judgments which we cited have been referred to for this purpose. The judgments which were cited on their behalf have been referred to with reference to res judicata itself. But the distinction feature your lordship may see page 61. Previous petition was by 34 individuals, out of which only 3 are common in the error petition. Then it was withdrawn almost 1 year before the result of recruitment declared. The said petition was withdrawn on so and so. Final result which is paid is on 1/6/2000. The question is, the result, appointment, everything is affected not by the fact that as to when this has been done. The question was whether there was leakage between 13 to 15 of 2021. How it distinguishes, and the same very prayers for cancellation of the same very examination has been made in the first petition. And all other prayers with regard to cancellation of appointment, etc., would be consequential. If the examination is maintained, no other prayer can be granted. So they say that in March this FIR was registered, and the finding is that orders being issued the basis of final result showed it is not concealment but rather a mere omission, and could not attract the bar of res judicata. This was not an argument. The argument was that concealment itself disentitles them. The other was that there is estoppel by virtue of the fact that they didn't seek liberty at the time of withdrawal of earlier petition in the for identical players. And then they participated in subsequent process. Some of them are those mirrored who participated up to interview. But because they were lower in the list, final result, they couldn't be selected.
From these petitioners?
These petitioners.
You have stated so in your.
What is important is that why did they wait up to the last appointment? Because of the fact, that in this case, the merit list in that very sense is not prepared. The final result, those who are successful up to interview, their list is prepared. So when offering appointment, they were waiting as to whether maybe that they get a chance of appointment. If they would have been appointed, they would have also. That is why, my lord, the service students, it has been said that if you consciously participate, know the things. Here is an additional feature, my lord, they knew the things, they challenged it on the same very grounds, except these two FIRs which have been registered later, and then withdraw them after a reply. It is not, my lord, that they filed it, didn't get it registered, it was dismissed in defect, or for reason of delay and later. That is not the case. They consciously withdraw it, my lord. How do a person exist in a situation other than this way? Then it is said to be mere omission, my lord, and when in rejoinder they say that there are 2-3 petitions, their number is given, and that petition in which they were petitioners, that number is not given in the rejoinder. So res judicata, concealment, estoppel, acquiescence, these were all separate submissions. Now, what is material fact, my lord? If a disclosure of a fact, this entitles a petitioner from maintaining the petition, and the petition will be rejected at the threshold. My lord, suppose in August, when he filed the petition and this fact would have been disclosed, and before any further investigation would have taken place, and the matter would have been heard whether his petition could have been sustained.
All right.
Can it be said, my lord, none of the judgments which have been referred to, one of them, what happens, my lord, they say that it should have affected, in one case it has been said, my lord, that if the dirt, if you come with the dirty hands in the court, if the dirt is removed, whether the petition can be maintained.
How do you deal with this judgment which he has cited?
Yes, my lord.
State versus BSK Realtors,
Yes.
where it says that the suppression and concealment should be material in nature.
Yes.
It would affect
on the
merits of the case.
Yes.
And actually, his entire view which he has taken
Yes.
in para 43 is
Yes.
that there have been glaring developments and significant changes in the pleadings of the present batch of petitions.
Yes.
And it was much after the withdrawal that SOG was formed,
Yes.
FIRs have been registered. And therefore, he submits that his viewpoint is that it cannot affect the merits of the case. This is what he would.
That when we examine the issue of maintainability of petition below, how meritorious the case may ultimately turn to be, cannot be the consideration.
That is there. That is there.
If what prevented them from saying in the petition that we filed and withdrew, we are filing it again because of the stress development.
But this is what he said.
There is no such explanation.
This is what this learned signature, honorable
This
signature.
is what is below when citing these judgments, if the judgments filing number would have been cited, referred to, and then distinction would have been drawn, it would have been different thing. I will immediately draw your letter of attention to those judgments, below how the judicial system should be saved from such kind of person who choose to make governments with regard to facts and choose to conceal them.
Yes. Yes.
Yes, and your lordship may have it from this KD Sarma judgment first 2008 12 SCC 481. There are 34 to 39 and 50. Yes, 67. There are 24 at page 78.
Yes.
The jurisdiction of the Supreme Court under Article 32 and of the High Court under 226 of the Constitution is extraordinary, equitable and exclusive. Prerogative rights mentioned therein are issued for doing substantial justice. It is therefore of utmost necessity that the petitioner approaching the court must come with clearness. Put forward all the facts before the court without concealing or suppressing anything, and seek an appropriate relief. If there is no candid disclosure of relevant and material facts, or the petitioner is guilty of misleading the court, his petition may be dismissed at the threshold without considering the merits of the claim. The underlying object has been succinctly stated by so and so. It has been for many years the rule of the court, and one which it is for the greatest importance to maintain that when an applicant comes to the court to obtain relief from ex parte statement, he should make a full and fair disclosure of all the material facts. It says facts, not law. He must not misstate the law if he can help it. The court is supposed to know the law, but it knows nothing about the facts, and the applicant must state fully and fairly the facts and the penalty by which the court enforces. For that obligation is that if it is found out that the facts have not been fully and fairly stated to it, the court will set aside any action which it has taken on the faith of the imperfect statement. A prerogative remedy is not a matter of force. While exercising extraordinary power, a writ court would certainly bear in mind the conduct of the party who invokes the jurisdiction of the court. If the applicant makes a false statement or suppresses material fact or attempts to mislead the court may dismiss the action on the ground alone, and may refuse to enter into merits of the case by stating, "We will not listen to your application because of what you have done." The rule has been evolved in the larger public interest to deter any unscrupulous litigants from abusing the process of the court by deceiving it. In question, your worship may have this note considered then the above principles, there are 38 the above principles have been accepted in our legal system also. As per settled law, the party who invokes the extraordinary jurisdiction of this court under 32 or High Court under 226 of the Constitution is supposed to be truthful, frank and open. He must disclose all material facts without any reservation, even if they are against him. He cannot be allowed to play hide and seek or pick and choose the facts he likes to disclose and to suppress, keep back or not to disclose until other facts. The very basis of the jurisdiction rests in disclosure of the true and complete correct facts. If material facts are suppressed or distorted, the very functioning of the court and exercise would become impossible. The petitioner must disclose all the facts having a hearing on the relief sought without any qualification. This is because the court knows laws but not facts. If primary object is highlighted in so and so is kept in mind, an applicant who does not come with candid facts and clean breast cannot hold a writ of the court with the soiled hands. Suppression or concealment of material fact is not an advocacy. It is a jugglery, manipulation, maneuvering, or misrepresentation, which has no place in equitable and prerogative jurisdiction. If the applicant does not disclose all the material facts clearly and truly, but states them in a distorted manner and mislead the court has inherent power in order to protect itself and to prevent an abuse of the process, to discharge the full mystery and refuse to proceed further with the examination of the case on merits. If the court does not reject the petition on that ground, the court would be failing in its duty. In fact, such an applicant requires to be dealt with for contempt of court for abusing the process of the. This was the judgment cited para 52 your worship may see further. In the case on hand, the appellant has not come forward with all the facts. He has chosen to state the facts in the manner suited to him by giving an impression to the report that an instrumentality of state has not followed doctrine of natural justice and fundamental principles of fair procedure. This is not proper. Hence, on that ground alone, the appellant cannot claim equitable relief. But we have also considered the merits of the case, and even on merits we are read out by him to interfere with the action of sale or the order passed by him. Now, therefore, what I am saying is that while taking a decision as to whether the court should enter into merit or not, if the learned single judge had ignored these principles, the effective submission which was made that RPSC may be served later. Firstly, this court should save its integrity. People who are playing with the court should not be given any credence. The Honorable Single Judge on the other hand will not goes to justify by saying that it is a bona fide omission.
It says it is not material.
It is material, my lord.
He says that it is not material concealment. He says that though it may, he doesn't say that it is not concealed. He says that there is a concealment, but this concealment is not material for the purpose of examining the merits.
That is what I am saying.
And
Yes,
therefore,
yes.
on merits, when he says
But
that
it-
we can't
but it-
close our eyes to the what actually has happened,
That is true, my lord. I am
and
not saying
therefore
whether-
he goes ahead and examines it on merits.
my lord,
Here also,
if this-
if you look into it, they also examined it on merits.
But may I say one thing? The state government never came before the court saying that nothing wrong has happened.
Yes,
We said that yes, we know that wrong has happened. We are investigating the matter, but we have not reached to a stage where it can be conclusively said that it was so widespread that the tenant cannot be separated from untenanted.
that is where he has gone further. And
Before going there, it was a case to be examined on merit. The Honorable Single Judge, while hearing the issue of maintainability, could not have presumed that ultimate result is bound to be cancellation. Let us assume we not
ultimate result would not have been a cancellation.
suppose.
That is what the presumes, and then proceed.
So it has to presume, my lord, that the things as they are may require examination.
There we are with you.
Yes,
That so far as that part is concerned with regard to the cancellation,
yes.
a presumption could not have been drawn that the state will not cancel the examination or the state will take whatever decision is.
Yes.
So that was not there before him.
Yes. But at the time of examining maintainability, my lord, also.
That should have been.
The matter is the hallmark of judgment. How can it say that it is not material if I am telling that the petition deserves to be thrown away?
All right, you got to.
The material, because the petition cannot be examined on merit, and that is the material fact which he must have disclosed. And they placed it before. In order to resolve the dispute, here is a false statement and declaration made below that no earlier petition has been filed. Falsity, my lord,
It goes.
Court, my lord, it's a very serious matter to say that it is mere omission and it is would be travesty of this. Then people will escape anything.
Yes, to that, if that is allowed, then it can be also bench hunting can be allowed. People can go for withdrawal and file a fresh petition.
Petition filed here.
He will be a file here and then get it dismissed and file it at Jodhpur. It is being done. There has to be some curve.
Where, my lord, the issue was where the reality of the courts to save the people from bad things is one part. But the court must also be jealous to see that the process of this court is not abused so that the faith of people is maintained. And only when a proper petition by a proper person comes, the issue of importance is examined.
Good
We
idea.
have suggested, my lord, to the honorable court that if the court is of this view, that it is of so public importance that the court.
It could have been taken so moto.
The manner provided in the law.
All right.
It could not have been done in this manner, my lord, by justifying wrong of the petitioners who are before the honorable court. And then the argument was of not of res judicata. Res judicata is a different concept, my lord. Argument was with regard to estoppel and constructive res judicata arising from Order 23 of CPC, which has been accepted as a matter of public policy and has been held that it applies equally to the petitions under Article 226 of the Constitution. And for that judgment, it was cited is, my lord, Question है 163 flag 9. Error in progress.
Sarguja,
Yes. And the honorable single judge relied upon thereof case. Because there will be.
but it was distinguished by two judges.
Honorable Supreme Court and still he relied upon that. And doesn't refer to this irrespective of having mentioned in the order.
For the Constitution bench,
Yes.
and the Ruyal case was Constitution bench. This was the two judges bench. Right in this.
It has been said, we know that, but on what the thereof case itself says that we are dealing with only the issue of res judicata and nothing else. Therefore, with reference to 32. So it was not an argument on res judicata, we know. Withdrawal without liberty is an argument which is independent. Shall I add your lordship, please to see, says the question of our consideration is whether it would or would not advance the cause of justice if the principle underlying rule 1 of order 23 of the code is adopted in respect of writ petitions filed under articles 226 and 227 of the Constitution of India also. It is common knowledge that very often after the petition is heard for some time, when the petitioner or his counsel finds that the court is not likely to.
Sir, it was left open. Actually, you come to para 9.
Yes.
The question was left open.
So there are 9. The point for consideration is whether a petitioner after withdrawing a writ petition filed by him in the High Court under Article 226 of India without the permission to institute a fresh petition can file a fresh writ petition in High Court under that article. On this point, the decision of thereof is of no assistance. But we are of the view that the principle underlying Rule 1 of Order 23 of the Code could be extended in the interest of administration of justice to cases of withdrawal of writ petition also, not on the ground of res judicata, but on the ground of public policy as explained above. It would also discourage the litigant from indulging in bench hunting tactics. In any event, there is no justifiable legal.
These are all only the part where these are their views. And the last line, please read. We, however, leave this question open.
Which one will?
The last line on this para 9.
No, it was with reference to habeas corpus being the.
No, that they say that for habeas corpus, our observation should not be taken into.
Yes, this is what.
But the entire question was left open.
No, this is with reference to Milord that every lordship.
They say even on merits we do not find. Therefore, they
Was right in holding that a fresh writ petition was not made.
ultimately, actually in all these matters, wherever these kind of preliminary objections are taken, the court also goes into the merits and sees whether.
There we last.
Because-
lordship may say something.
See, what happens is, when a technical objections like they taken about earlier petition having been filed, second petition having come before the court, and the court finds that on merits also there is nothing, then on this preliminary objection, court usually dismisses. But if suppose there is some material thing which is required to be examined, and it has not been earlier examined at all,
Yes.
then the court would definitely go to.
It would have been a simple argument of res judicata, it is okay. Secondly, Milord, if it is the court where there is no further remedies available. If the Honorable Supreme Court, Milord, examines it, because let us say there is no further remedy, no injustice should take place, and therefore examination then come back on the question of mental ability is a different thing. But where there are remedy after remedy available, and the court laid down the principle with reference to jurisdiction to it. It is not an issue of Milord giving quietus to the matter. It is a question of Milord entertaining the petition. Order 23 and section 11 are completely different things, Milord. And because CPC doesn't as such apply, the court has to see whether it is a matter of public policy or merely a matter of procedure to advance the course of the case. It is not that, my lord. It has been said that it is a matter of public policy.
Advocate General Sahab, the judgment which has been cited by the learned single judge, 2023-16 SCC,
Yes.
para 51 at page 70 of the judgment.
Yes.
That is the law as it stands today.
And yes. This was
The view which has been expressed. No, this is the view which has been expressed in para 51,
Yes.
which has been quoted.
Yes. Yes. This is not the second cardinal principle of exercise of extraordinary control is that in a given case, even if some action or order challenged is found to be illegal or invalid, the High Court, while exercising its extraordinary jurisdiction, can refuse to upset it with a view to doing substantial justice between the parties. Article 226 of the Constitution grants an extraordinary remedy, which is essentially discretionary, although founded on legal injury. It is perfectly open for the court exercising this flexible power to pass such orders and provisions as dictated. And equity projects. The legal formulations cannot be enforced divorced from the realities of the facts of the case.
Yes.
While administrative
This is the aspect which we want to the legal formulations which are generally applicable to civil law or to other places. If in the particular facts of the case you find that they can't be a reason for not examining the issue involved.
No, that is where
That's the slight difference between the powers under Article 226 being exercised and the strict principles which we lay down for the purpose of yes.
That is because if suppose there would have been no declaration by the Honorable Supreme Court on the issue with regard to 226 as to the principles which are analogical.
No, but he has also looked into particular judgments.
No.
Though we agree with you that he should have examined the judgments cited at bar, they should also.
From this observation, whether this is ratio of the judgment, it was a question of molding of relief. Second, Sudhakar is also molding of relief. What first part says that even if it is invalid, the court can refuse to court doing substantial justice. It is rendering of petitions infructuous. We know that this was being dealt with. It is not with reference to concealment action or filing. It is part 2, which is it was relevant to amend pairs rendering the petitions infructuous. It has been relied upon that even if I don't challenge, the court is entitled to more than relief. And these highlighted observations, my lord, are doing equity when the court decides the matter on merit. It is not for considering as to whether the merit should be decided or not. When it decides, it can of course, my lord, grant relief, refuse relief, more than relief for the purpose of substantial justice. It will be, my lord, completely ignoring the law which has been laid out with an exception of habeas corpus. That if somebody, my lord, withdraws without liberty, he has to go home. And here in a situation, my lord, where more than 3 lakh persons participated, the court would not have assumed, my lord, that they were so they won't come to the court independently and the other court would be failing in taking care of a clear situation. The very fact that out of these persons only they were there and this matter ran up to 1 year before. Nobody believed that at that center some leakage was there. Now leakage हुई उनमें FIR.
On merits come, let us know.
When the court turns down a question of maintainability on account of public interest, it has to be seen, my lord, who had approached and why others have not approached. It was highlighted throughout the proceedings. No one else with additional material came to the court and said that at my center also these things have been reduced. It's very important, my lord, because ultimately when your lordship go on to merit, three principles which have been laid down. One is tented, segregated from untented. Then there must be material to reach to an appropriate conclusion. It can't be below what the report says. What a charge sheet.
Whether that is the material which we'll have to examine, no?
No, that material is merely an opinion, and I will not make something to be. That intervening discussions, reports, or opinions which are expressed and not ultimately accepted by the government, they are part of decision making process. They can't be basis for saying that it should be done like this. The court can say, my lord, that if the final decision which we take, rather they too also into the effect that at this juncture it will be premature to cancel the examination if it would have been questioned by saying that the material which has come so far doesn't lead to this decision, and therefore this decision request, it would have been a different thing. It is a petition for mandamus period in a situation where government agencies have been doing everything. Whatever we do today, tomorrow it is with an affidavit or without affidavit before the court, and they are alleged of being biased. Can it be said that there is any malice in the mind of the government who itself gets the matter investigated and proceed further and continues to proceed further? What are the grounds on the basis of below judicial review is entertained? If there is an inaction in performance of public or statutory duty, if a decision is malicious or not bona fide, how can somebody elect? Because all these facts must be borne in mind, even when the question of mental ability to override what is just to be generally done, a step is taken forward to examine the merits.
So you had not taken any final decision.
We said we wrote that from the material which has come up, because the earlier report was of 13th August. We were taking decision in month at end of June. Before that, we collected the material, asked the SOG itself that the progress was examined, and then we reached to the conclusion that
As on today, what is the report of SOG and what is your state?
Reason below that this matter having been directions having been issued partially state, partially not state. We wanted an early hearing and decision and whatever we decided, but the question is below that decision is not under challenge. They cannot allege malice below on the part of the government when the government unearths the wrongdoers. Book them, get them punished. One example, if these persons will go to police stations, what will happen? We said below that those who should not go to the police stations are behind the bars. But those who should be there and the police stations are lying vacant, what will happen to the people? Against whom today there is no material. Let us go by this in this way. If you would not have been doing anything, you would have remained silent after this 22 dismissal of the petition, nobody came and let people go and do it. It would have been completely different. But when we, having found that in many examinations this is happening, there are gangs operating, we start investigation, book the people, we will screen those who should not be in the police station, and we have no material with regard to others who should occupy the post and render justice to the people. That is another way of looking at the things. It is without extrapolation of wrongs of others against whom evidence has been found that we start looking at everyone who has succeeded, saying that yes, they are bad men, they should not go to the police station. If this is not the way, we know those three principles which have been laid down by the honorable session should be applied. There is systemic failures. That is not because no gangs operating outside, they will continue to operate in any examination. But their existence doesn't make a system based. If there is systemic failure, in the sense that the system itself, as Bengal.
But here this Ladet Singh says that there is a systemic failure
That finding will not would have been
regarding the RPSC.
before going into merit, there was large scale material available before the honorable court to see that the government is rather the honorable citizen appreciates the steps, and it is still below the decision taken by the government that at this juncture it is not a fit case for cancellation in their resolution or the decision of the committee itself read in a different way by modification in the order. This is not done before. If the court was of opinion it should be cancelled, the direction should be that it is cancelled. This is an opinion given way date in August. Subsequent water having flown, a fresh decision having been taken, it is not under challenge, relying upon that opinion of August. Or based on that report, the court says that the government will first collect the material. No, government is saying the material available is not sufficient for taking this decision. No, direction to the effect that you prepare a report, collect the material, give to RPSC, and then RPSC should take a decision as to whether it should be cancelled or not in the wake of the finding already recorded that it should be cancelled. Hearing this said to be conclusion, it is full of contradictions. And therefore, my submission in below if the honorable citizen was not very sure that it should be outrightly cancelled by the court itself, then why preliminary objections are being rejected? The court would have recorded upon it that it is a fit case to be cancelled. And then all these rigmarole of the government, forcing the government to bring the material, support it, and then send to RPSC, and then RPSC taking decision. Lord, what kind of decision that will be? When there is a finding that it should be cancelled. Why additional material or a report to RPSC is required? There also the CD directions issue. Therefore, my submission is below that it is contrary to the law declared by the Honorable Supreme Court. The question of res judicata has been intermingled with the principle of public policy in relation to non-timely petition under an assumption that actually large number of people are affected. They are not coming to the court.
What he has written in para 117 onwards,
Yes.
I was looking at that. From where this has come? Para 120 and that,
Findings are there, ultimately. what
now
is
from
done-
where these findings have come?
They-
On basis of what? Like in para 122, in order to ensure that Shobha Raika secured good marks in the interview stage, Mr. Damuram Raika met so and so the chairman. From where has it come that they met and they did all this? This is a report of the.
There are, your lordship, not in course of investigation.
They prepare in that is part of the charge sheet. So that statement that has been made as a charge sheet part.
And
So-
that is made as a part of charge sheet.
So that is to be examined by the concerned court.
Courts
We can't take it there.
taking it as a conclusive proof of certain things. It is a very different situation because one statement is not even entertained as evidence. But that I will not go too far to say that unless the court examines. The question is whether these are preliminary observations of an officer. Based on whatever investigation took
All
place.
right. That will take its own course.
Yeah. And if the investigation agency says that with further arrest we will be in position to segregate the tented with untented, how can the court and on what basis the court can say that it will be impossible? These are not, these are all administrative functions or statutory functions discharged for the purpose of investigation of crime. That doesn't make everybody guilty, And the reasons given this cancellation will result will not give a pointers to the anxiety of the people. Why the court should entertain and create anxiety? And there are certain observations, they have filed their own appeal and they will say what is there. During the course of argument, the Sanjay Shrotriya, etc., there is no material placed by them and argued in court. The court has been recording the order sheet almost every day. There is no argument with regard to persons who, about whom this underlined observation at page 175 has been made. So, charge sheet may not, there may be some observations with regard to that. But if they have not been made accused or has not been found to be sufficient for holding them guilty of something,
Okay.
so this was the second submission on this. Another judgment of this honorable court was also cited. That is Hanuman Singh versus Board of Revenue. Page 171. This also relies upon Samhita judgment.
Which one?
The item 10 Hanuman Singh versus Board of Revenue. This honorable court relied upon Samhita and said that this the question was formed by the
And this is a larger bench judgment.
larger. Question was formed for consideration by his whether the decision of Sarguja Council Service to locate as an absolute bar against entertainment of any subsequent writ petition when earlier petition has been withdrawn without liberty to file a fresh petition. And in no circumstance a second petition can be entertained by the High Court on the same subject matter. The answer given
Para 7.
it's an absolute bar. Except as this there are 9 age or also.
Yes.
So when these judgments were cited, they say that it is an absolute bar. The question of jurisdiction, as it has been said, that the question of competence, there is no moksha from that bar. Justice I have said, however good an intention may be, if one cannot do one something, it cannot. Or it is required to be done in a different manner, it should be done in that manner. Then third submission was with regard to prospective adjudicator also. Adjudicator requires a decision on merit. But the points which you could have raised and placed in an earlier litigation, material was available with them. If they choose not to place, but apart from that, the question was that delay and later in recruitment matters. The court said that the first cause of action arose in 2024 after the arrest was made. How can there be they could be saying that earlier there was no cause of action to them when they filed the earlier petition in 2020. The delay has to be examined not from what is revealed in the investigation. It has to be examined. The persons must be agreed by the fact that there was leakage on those 3 days, which came to knowledge of people and the FIRs were registered, they came to the court. No further material being available cannot be a basis to say that the petition is not guilty. Suppose the SRB or SIT would not have been constituted and the FIR would not have been registered. Would it not be delayed? It is further investigation into ongoing investigation. But as a matter of fact, there was a FIR already registered in which investigation was going on and further material came. No, what the court says is, in this regard, delay and legend is very interesting, you know. That it is only when the arrests, etc. were made. Appointment here and what is said is, my lord, the lordship may see one thing, my lord, which is important is that in the prayer, in the all prayers in the petitions are they get the investigation properly, monitor it, and cancel the result of the examination held on 13 September 21 to 15 September 20. This is the main thing, my lord. The Gulwar or the foundation was everything else in the case. So other players may have to the effect that the appointment be cancelled, this be cancelled. They are all considered. They don't say that the appointment has been given by for a person who was not in merit has been given the appointment. I am entitled in place of him. That was not the kind of case. It was a case that the examination process on to those 3 days. Its sanctity is not maintained and therefore everything should do was the prayer. And this was the prayer. Now, how the addition of prayers of cancellation of appointment, etc., which are consequential to the main prayer, changes the character of the litigation. Rather, it indicates that you await till all appointments take place. You are not a fence sitter. You, as a matter of fact, after everything comes forward, all back and abstain yourself from knocking the doors of the court. And then come and say that now that the arrests are being made or appointments have been made irrespective of registration of FIR, they give the fresh course of action. Can that be permitted? Third party rights have been, they allowed the creation of third party rights by withdrawal of that petition. People have resigned, will not be details have been given. There were ex-servicemen, there is a chart which has been reproduced in appeal and it was considered by committee that large number of persons are those who have resigned from their services and they have then accepted the appointment because they were selected. So all the matters went to the root of the matter. Where the petition as a matter of fact, so far their petition is concerned should have been dismissed. If some appropriate petition would have come, it would have been a different. And people not coming to the court, because during the course of the hearing, it was told that people may be afraid. No, those who have not been selected and want cancellation of result, from whom they will be afraid, why they will not come to court for cancellation. Till appointments were made, people may be afraid. Even if it is said that in interview, I may face something. Interviews were over. Merit list preparation, there is no fear, my lord. If there is manipulation in the marks, it will be revealed and can come. After the last appointment order is issued, my lord, they approach the court. They should make false averments, my lord, without any material. That the administration is pressurizing SOG not to recommend cancellation. How can a person who creates a story contrary to the report which they themselves later on submitted be allowed to continue with the petition? I may read from the government's report in the petitions. There they make a very interesting reading. On 13th August, this petition is filed. And in para there are 25 of the lead petitions there on 13th August when a recommendation for cancellation had been sent. It says that when the among petitioners met as SDO, it should be opposing authorities to know about the progress of investigation. They were agreeing that huge pressure is being exerted on administrative level to stop the investigation and not to make recommendations for the cancellation of SI recruitment 2021, and therefore humble petitioners are left with no other alternative except to approve this honorable court with the present petition to monitor the investigation of SOG in respect of paper leakage of SI and to cancel the entire exam and subsequent appointment of a home court leakage in systemic manner which has cleared the entire organization. No, there's administrative and can they just submit the report themselves. Or they nothing but itself when the petition is filed. Contrary to what they say, that SOG people have told them that they are administrative pressures to stop the investigation. And then next humble petitioners also made the state respondent official with request to cancel the entire and to cancel the appointment order. However, they did not accept the request of humble until then. The entire examination process has not been cancelled by the also appointment orders of have not been cancelled by not there with whom they made. Creation of a cause of action where it never existed. And this prayer also contradicts with any assumption based on the report. Because the prayers are that the other involved, the court should be monitoring the investigation. These prayers can be made only when you don't find the SOP doing the right thing. So when a report in your favor comes, you say that this is the conclusive proof. Until the report was not available to you, SOP was acting under administrative pressure. Can such tactics be allowed, my lord? And specific argument was made to the effect, my lord, that the materials which ought not to be available, even under RTA. No material placed before the honorable court has been sought and placed under RTA. My lord, all these reports, etc., have been coming and the judgment was cited to the effect that the court will have to see as to whom yes, the individuals are functioning when such material comes on report. The judgment cited was my lord with reference to this was the court said that it's such. So the argument was made that in one judgment Sinha's case, it was defense was taken, it was lying on the road and we wrote. Response Sinha was a case in road where the question of Article 19 was being examined from the point of view of the right to speech and expression and right to have information. In that context, something was said. But it is the court when your lordship examine the conduct of the individuals before your lordship and the flood of material being supplied almost on every day, which is ongoing things which must not come out in public because they may warn the people. What is important is not that report being available to them and brought to the court may have warned so many accused whose role has been doubted in the report. So first you make the fair or the effective investigation difficult and then say that now that it is difficult therefore cancel the examination. These conducts could not have been ignored, my lord, by saying that now that the material has come before the court.
Yes.
So my humble submission is, my lord, the other argument was with regard to waiver and acquiescence and appropriating and reprobating. These very persons who, my lord, remain satisfied with the examination in 2020, whatever material may have come later, they are not the persons who should be allowed to say that now we are.
And they have participated in the selection.
And they participated in the election, etc. And they don't disclose that also. At least they must have said that up to this stage we got success. And if everything would have been fair, we had a chance at least they only no inaction alleged, no failure in statutory duty alleged, writ of mandamus sought. We my lord cited a direct judgment on this, my lord, to the effect that the court should not directly take a decision by issuance of a writ of mandamus. It should be left to the authorities. And therefore, in given situation, the Honorable Supreme Court gave an opportunity to the government to take a decision. And it was said that let us give an opportunity and that decision then subsequently can be challenged. In that spirit only, may not be court allowed us to take a decision. We take a decision that is not challenged. Nothing fresh has been said. There must be, why they were silent, they will have to appear on report to say that we were bona fide making this or that, nothing is there, and the submission with regard to denial is done. And we cited judgments with regard to recruitment, my lord, once a person participates, remains silent. Because in ordinary other cases, my lord, third party rights may not have to. It is not merely a matter of deciding questions of rate of 800 persons. It will be mirror affecting those who apply it also. If I have to give a fresh chance, I do not know how many of them have gone already in other services, who will be participating, who will not be participating. Recruitment is a big process and it has impact upon the administration. When we talk about public interest, it has to be taken care of that the intervention of a court without very strong reasons in the matters of appointment without it, particularly of this kind, affects the very administration of justice itself.
Yes.
So, in my humble submission, that the I have given the index with regard to the preliminary objections and the issues which were raised there. And along with there also I want the reading from them. I am on the question of as to whether the petitions became infructuous after the decision made allowed by the court was made, and it was not checked. We cited a judgment before it is that like 26 hours versus High Court of Patna. Sorry. Case 360. The relevant page is 58. There are 5 statements. The registrar general will apply report as finally detailed on the website. Including copy of the judgment passed by the division bench. In particular, it was asked that SLP has become infructuous in view of the subsequent hearing. In our view, the submission is justified in view. All that was reflected in SLP was the order of division bench attached transcripts. In admitting the agreement, the final order passed by the division bench.
You are reading which para?
There are 5. Case 338. The appeal was admitted, the matter was heard in final decision making, in such circumstances. The proceeding initiated as per SIT has become infructuous on this note ground. So once a petition is filed in absence of a decision with an allegation that they have not decided to cancel, and a consent decision has been brought to the notice of them, as well as was placed before the honorable court, it was their duty to have challenge it and raise grounds for specific grounds for that, because we do not know, my lord, on the basis of what has been said earlier, how it will be assessed.
Yes.
Now, one aspect of the matter of which I draw your lordship's attention He is the principal. The judgment without designated, there are two judgments without to consider the issue on merits. You also will require two judgments which had referred to all the earlier judgments without and then reached to conclusion, and that is what has been mentioned, but whether they apply in this case or not is important. It is one judgment without which I want your worship to notice. 25 without state of Odisha versus Lakshmi Narayan. Even though I have put it in the category of department and communication, it has been referred to on various grounds. Because all these submissions which I have been making before your worship and I made before the honorable sitting judge, all these points were raised in the judgment and answered in favor of the questions raised. Delay and latest, etc. 24 in on almost every submission being made before the law. It's a detailed judgment below on all those. So I am not reading the whole of it. I am reading indulgence for noting it, and when necessary, I will read also.
Yeah. Yes.
Please take item continue. Page 183. From red notes itself, it will be clear below that all these questions were raised unanswered. Now, on the issue as to whether or not the court has considered the matter properly on merits. The Honorable Single Judge has relied upon thoroughly and mainly upon a report which was submitted by the Chief of SID to the Director General of Police, making several recommendations. Yes,
That report was placed before the court.
that report was placed before the court by them. Then,
So where was it being available to them? How was it made available?
since that neither it has been sought under any statutory provision.
But who has made it available? SIT made them available.
No. That is why we said that we want the.
Or was it directly brought before the court directly by the SIT?
No.
SOG placed it before the court?
It's not placed. After we got this filing of petition, where they were saying that the SOG.
That 13th August.
13th August, they were under they said.
That report is of 13th August.
Yes, same day. While coming to the court, they were saying they are not going to do anything because they are under arrest. No sooner this report travels at higher level below, at what stage and to whom it was referred and who shared it, it has not been disclosed because it a material which cannot ordinarily be available, the affidavit requires to state the source also as per the High Court. It cannot be said below that simply it has come. How does it matter where from it comes, whether the government denies it? That is not the answer to it. It shows below that if a person is approached to the honorable court, whether he is himself approaching it for a purpose or there are some other people who are behind the game, that becomes material because not only this report, thereafter below the letter written by the government, that becomes available to them. Everything which was transpiring becomes available to them and it is filed. No, those were all. What I wish to say is, they were all matters which were in the process of considering a issue. And these judgment method which I cited, this Lakshmi Narayan Das, apart from that method, the Bharti Sports Club is a judgment method which clearly designates that the interdepartmental communication or cannot be made this. Then we wrote this Scottish Uddhav Singh 61 where that is. The question is, what were these materials which were in the process of consideration and were tentative. What is important is this, because it's the investigation.
Was a charge sheet filed in the court?
Charge sheets, multiple charge sheets have been filed in the court.
So those charge sheets were produced.
Later on, some of them, those charge sheets were also produced. But the question is
Whether the learned single judge relies on this report or on the charge sheet.
later on for some portion with reference to one charge sheet also. The question here is, that when charge sheet is filed, if either the court relies upon wholly and lawfully upon a particular document, or
So what do you say?
what I
Now whether that consent judicial officer judicial magistrate where the charge sheet has been filed
yes,
can go beyond what has been said by the High Court.
that is one aspect. I am on some other issue. The other issue is, that if a investigating agency has said something in a report, even as a preliminary check,
It is not concluded. They have sent it for public interest litigation. The final part of the order to
that's what I said. If it was to be sent, it should have been sent earlier. Now the court knows, that as to bring the matter of public importance.
has it been registered? Has
It
it?
has been registered
Notice in
of the pendency of this appeal. Which is also subject matter of the LM before comments.
notice issued.
In that case,
Yes.
Sir, the registration which has been made, notice may have been issued below the metropolis is to be heard. It will be
where is
heard.
it? It has not come.
It has been issued.
When?
Date, I don't know, but special bench was formed, I think, for that.
When was that special bench formed? Was there a special bench formed?
Well,
This judgment?
Provide the details to the motion may call and see as to what it is.
No, we would like to know if that is there, then that has to be heard.
Yes, it has been registered in the country.
That's all right, but whether
Sir, the number is CW 13601/2020.
Yes.
2025.
Yes, sir. 13601/2020.
Notice was issued on 16th October.
देखना भाई सब्सक्राइब किया लगाइए फाइल
There was an improvement, it is not with non-registration, etc. It is an additional which is been registered and registered. It could be then which has been constituted by the Lord City. Honorable Mr. District Executive and Honorable Mr. District. On 16th October, it was directed the now my assistant.
Should park and on in the bridge. 8/9 2025. Para 50,000. States in the meanwhile and think for the orders. Fact and operation of the ship, where they can 28 May 2025 past where the second. He has been in the decision of much financial other connected movement shall be in state. Till the next date of the.
then
This
Supreme
order was before the Supreme Court.
and then Supreme
Court interfered only to the extent
said that
that they will not be even posted.
Yes.
That's what the part we will have. No, 15. Supreme Court states, in your order, we can make out that the matter is state on 8/10/2025. Because the High Court decide appeal expedition, preferably within 3 months.
that should be within this case, no? These are also those appeals, connected appeals.
Yes. Therefore, I say. in
So,
this
but
case,
why is that case not listed?
But since there is an interim order.
Interim order is in that case. In these appeals, yes. In these appeals, we know that there is an order and that was modified by the Supreme Court, that part. We wanted to know that. What we want to know is that when they're relating to that PIL, which has been registered.
The order is part of the order which has been stated.
It is not a separate order, because it is in the primary order.
But that has been registered as a PIL. So if it is there, then it has to be also disposed of accordingly.
Yes.
With this case.
What I want not be part of what I want to convey.
It is not a part of this file. We will be telling, we will calling for it. No? We will have to.
This interim order was part in now.
In your cases, we know. The state appeal came later on. But since.
There is an order staying operation of the judgment of the learned single bench.
Yes.
And judgment says that register the PIL and prosecute the PIL. So registration and perhaps has been, might have been done prior to.
We will just check it out. That is why we are saying.
But then, since there is interim order, therefore PIL, my understanding cannot be.
Also, if I may clarify, para 15 and 16 was also stayed by the Honorable Supreme Court. Therefore, the PI was listed subsequently.
The order itself.
Para 15 and 16 was stayed.
The order.
Para B, we stay the operation of the direction issued in para 15 and 16 of the impugned order. That is why that was subsequently listed last week. We so move to that.
There are 15 says the meanwhile and will further
Supreme
order.
Court order.
effect and operation of the judgment are the
Supreme Court order.
in any case, sir. Right, also, for any reference, I must pass on. Please take this. I have only one copy at the moment.
All right, we'll do.
On the PIL, can someone like,
The para 15 and 16.
PIL, I am told that we are not party.
You made petition, this may order pass हुआ था, हम वाला है. Will para 15 and 16?
15 and 16 of your lordship. We order dated 8/12.
Now, it says in the green line, three further order, effect and operation of the judgment dated 28/8/2025. Passed by the single judge in the admission number 13806 of 2015. Another connected method shall remain state in next date of year.
They modified it. And passed.
However, we noticed that the entry order passed by the next single judge. This was not disturbed by the next division bench. In appeal, therefore, we direct the state government not to make any field postings of the selected sub-inspector under the concerned main selection process.
That is why the PIL must have been registered. Yes. Yes, anything further?
With regard to mentioning the order, so my first solution would be that this petition is not independent and decided. On merits, may I seek your lordship suggestions to start with and conclude tomorrow?
Tomorrow.
Because it is a separate.
क्या हुआ tomorrow?
दो बजे टीवी पुस्तक है 2 बजे जयपुर से एसएमबी और फिर 3 बजे जयपुर से एसएमबी
इस बात की
सर 3 बजे शाम सुप्रीम कोर्ट के वेटेड चल रहे हैं 2 बजे जयपुर से एसएमबी 2 केसेस
वो क्या है?
कॉलिंग एप्लीकेशन से
उसको डायग्राम कर दो 2 बजे से 3 बजे तक
तो वो से एक्टिव कर
वो से 3
वो 3 बजे वो एसएमबी कल पट्टा करना
तो है.
कल वैसे टॉप ऑफ द बोर्ड कुछ भी रखा हुआ नहीं है कल.
Can we take it up in the morning at 10? We'll take it up at 10:30. We'll continue with. Direction of Supreme Court, we can't do anything about it. You only got it done from the Supreme Court.
10 or 10:30?
10:30.
We make even a combination of the.
Should be notified from other banks at 10:30.
No. You can have it at 10:30 onwards when the courts. You want that we should prepone the court from 10. You want another.
Without any, strenuous intervention, then we can come and argue. Provided he has to argue that this can be.
Mr. Anand Mathur, you are treading on very dangerous waters.
So I express my opinion on the course.
Continue. Go ahead, continue. Any particular important matter anybody wants to make a mention relating to any pending case? We have 10 minutes with us. Hmm? 160, all right, we will hear all the cases together. 164 also we will.
State appeals. They are not state. So medical is to them.
Give the number. Give the
I
number.
can give the number.
We will get that PIL also listed so that has to be decided for together.
There are state appeals.
Hmm? नहीं लगा all right उसके लिए भी पता नहीं 150 what do you want naturally when there is an appeal before this court and the court has already put it for hearing then how can any contempt proceedings can continue stay dismissed हो चुका है that you then pursue your contempt proceedings